Welcome, everyone. We are at the Charleston Gazette-Mail Candidate Forum with Supreme Court candidates for Division 1. My name is Kelly Merritt. I am editor of the Daily Mail opinion page of the Charleston Gazette-Mail. We will introduce our panel here from the Gazette-Mail, and then we'll give each candidate an opportunity to about 1 minute to introduce themselves, explain why they're running, and then we will be asking questions. Again, I'm Kelly Merritt, Daily Mail opinion.
Bill Candler, State House reporter.
Field City Editor.
I'm Noah Miller, the Gazette opinion page editor.
I'm Jora, I'm a exchange student from Ukraine.
I'm Greg Moore, I'm the Gazette Mail executive editor.
I'm Chris Dorson, photographer. Gazette Mail.
Thank you, Mr. Merritt. My name is Bo Bruder. I am for change at this court, and I will bring change and real change to the court. And I'll lead by example. Public trust can only be restored with public service, and you have to know the definitions in this election. What your definition of public service is critical to the change candidate there. Now, specifically, I'm going to use $8 office furniture. Many of you have seen me on the campaign trail with my law office desk and chair. Secondly, public service is defined by sacrifice, and we've had admitted indefensible spending, admitted illegal spending. So I'm giving back $200,000 of my Supreme Court salary if you elect me as a justice. $100,000 per year, and just last week we had a justice pay back $2,000 for improper illegal lunches. But when the question was asked, well, why don't you write a check for $131,000? I'm not going to do that. Well, this candidate is. Thank you.
Good morning. I'm Robert Carlton, candidate for the Supreme Court. My responsibility will bring stability to the Supreme Court, and in doing so, I'll bring my expertise from my lifelong experiences. I have a law degree from Oral Roberts University, which is now CBN University, Virginia Beach. I have diplomas from both for the same period. From there, I went on to, and later in life, attended West Virginia University and received an MBA degree. I have over 300 college hours and 6 college degrees total, some of them 2 degrees. Over the years, I've served as a magistrate in West Virginia, as an adult probation officer in West Virginia, as child advocate in West Virginia, as assistant prosecuting attorney in West Virginia, as defense counsel in West Virginia, and currently have a private practice in personal injury and bankruptcy law. I spend a lot of my time in federal bankruptcy court. I look forward to being able to help the people of the state of West Virginia just as I've helped them over the years. West Virginia is a hard place to live, and we need to keep in mind that people have hard times, and that's one of the reasons I do bankruptcy work. I stop foreclosures and help the average person. Appreciate it if you vote.
Good morning, my name is Ron Hatfield. I'm a veteran of the United States Marine Corps. I'm a lawyer from Huntington. 18 years of courtroom experience, both criminal and civil. Currently serve as a local managing partner of a nationwide law firm serving clients in 36 states from 22 offices across the United States. As I said, I live in Huntington with my wife for 20 years. We have 2 daughters who attend public school in Cabell County. I'm here today, and I'm running for the Supreme Court because the unusual and unfortunate set of circumstances that has brought us to this election and the election of Supreme Court justices allowed me to look back on my career and realize that I'm satisfied that I have accomplished what I set out to accomplish as a lawyer. And this opportunity and honor to run for the Supreme Court gives me the ability to use all of the training and education and skills that I've developed over the last 30 years, stretching back to the Marine Corps, my courtroom experience, my time as a business owner. I've run a solo firm, small practice, and now part of a nationwide firm for the last 13 years, and also the financial responsibility that I have learned throughout that time, running my own business and growing successful law firm. So I appreciate the opportunity to be able to use those skills to move beyond one-on-one client interaction and be able to use all of those things that I've developed in my adulthood to make the entire state of West Virginia better.
I'm Mark Hunt, and this is not my first time before this group. Most of you, I've been a lawyer for almost 25 years. I practiced in state and federal courts. I've represented more than 5,000 clients, somewhere between 5,000 and 9,000 clients, because I used to do defective products and do mass torts. But anyway, I've been married for 20 years to the same woman. We have 2 children, one 14 and one 17. My 14-year-old son is thespian. He was just in Charlottesville, one of the leads, and plays the piano and guitar. Still in high school. 17-year-old is graduating. What direction he goes into. But I'm running for this office because I think what's important to restore is trust. I think that the people of West Virginia need to be able to trust that their Supreme Court justices are honest and working with integrity. And if they don't trust their justices, they're not going to trust the decisions coming out of the court. I served 14 years as a state legislator. I served and was elected in 3 different districts. During that time, I had 0, and that's 0 expenses. I never turned in anything. I never asked for a lamp. I never asked for a rug. I used what was there, and if something broke, I just got to hand me down to another office. So as far as that kind of foolishness, if that's what this is about, I have a record of 0 expenses. And that's in the days when the legislature would go on junkets. I refused every one. That's when we held interim meetings in parks. I paid my own way. So I figured I was getting paid enough money for a 60-day job. So I think I'm a person who has a record of being able to bring trust back to the court. A record, not wasting public money.
Hi, I'm Howard Lewis, and I appreciate the Gazette-Mail for having this forum. It allows us to get our message out, and I think it's a very good public service that you all are doing. And you've always done this over the course of the years that I've been running for office, and I really appreciate it because it's been a source for an unfunded candidate like me over the years. It's really important that we get our message out. My message is simple. I believe that fairness plus freedom equals prosperity, and that we have to have fair, non-biased, 100% non-partisan, fully elected West Virginia Supreme Court. I plan to work until that is accomplished. Currently, I don't believe that the Supreme Court has jurisdiction because it is unconstitutionally unfair and impartial at the current present state of affairs. The legislature and the people, through the legislature, have voiced that they want a nonpartisan election of judges, including justices of the Supreme Court. At that point in time, when the people say that, because they're vested with power under the Constitution to determine whether or not we'll have nonpartisan or partisan elections, that is when the court has to become nonpartisan. And the current process is flawed in that you've taken the Speaker of the House, who's 20 years in the House of Delegates, as a Republican Party official and member in the leadership. He's going to be tainted. His entire term is going to be tainted with bias. He also worked for the natural gas industry, and there's a lot of natural gas litigation that's going to be coming before the court and has come before the court. And it's going to create a situation where he's going to be asked to recuse himself. In natural gas cases, in government, anything involving the governor, anything involving the agencies, the executive agencies of the state, all those he's going to be asked to recuse himself. And under our current recusal procedures, under Rule 17, and the guidance from the Judicial Investigation Commission, we have a subjective standard in the state of West Virginia. The federal standard is objective, based on a reasonable person, whether or not there would even be an appearance of bias, is the federal standard. There is clearly an appearance of bias in the current makeup of the Supreme Court. And until we have fully 100% elected by the people, nonpartisan, non-biased judicial officers, when the court comes in session like today, and the bailiff announces that the court is in session, the court doesn't have jurisdiction under the Constitution, because the Constitution requires a fair and impartial tribunal. And it gives the Supreme Court that power. As an elected member of the Supreme Court, I believe I can beat the current appointed justice, and I believe I'm the only one that can win. So if you don't support the biased court as of right now, and governor's selection, then I would ask that you vote for me, so that we can win and turn the court around to be a non-biased, non-partisan, fully elected, 100% Supreme Court.
Morning, my name is Joanna Tabbitt, and I'm a circuit judge here in Kanawha County. I am a lifelong West Virginian, and I'm running for Supreme Court because I believe that now more than ever, our court needs a proven, qualified judge. And I'll tell you a little bit about my background. I've been on the bench here in Kanawha County for 4 years now. During that time, I've tried numerous complex cases and presided over hundreds, if not more. Prior to that time, when I first got out of law school, I actually worked at the Supreme Court of Appeals for then Justice Thomas McHugh. After that, I worked in the Attorney General's office and practiced appellate law as an assistant and deputy attorney general, practiced almost exclusively before the Supreme Court of Appeals. After that, for about 22 years, I litigated exclusively in state, federal appellate courts here in West Virginia with the law firm of Steptoe & Johnson. And as a circuit judge, have had the honor of being appointed and sitting as a special justice on the Supreme Court. So I've worked at the court before. I have practiced extensively in my career in front of that very court, and have had the honor of sitting on the court as a special justice. My vision for the court is simple. I believe it should be fair. I believe it should be effective, accessible, and accountable to the people that it serves. And I certainly look forward to discussing that vision a little bit more during this process. Thank you.
Good morning. My name is Chris Wilkes. I'm from Martinsburg, West Virginia. Been married to the same woman for 34 years, father of 2 daughters, and relatively recent grandfather to my first grandson, Jack, and 2-year-old daughter, Isabel. My daughter, Katie Wilkes-Gallagher, is the prosecuting attorney in Berkeley County. My daughter, Lauren, is an elementary education student at WVU. I, for 10 years out of law school, practiced with my dad in a general practice, you might call it a country practice, doing all kinds of work. And then I was lucky enough to be elected in 1992 to the circuit bench in the 23rd Circuit, which has now become the largest and fastest growing circuit in the state. And for about a decade, I've been the chief judge of that circuit. I'm running for the Supreme Court because I think we are now suffering from a judicial crisis. The public does not recognize there are over 250 dedicated, decent judicial officers in this state that are getting painted with the same brush that the Supreme Court is being painted with. But we can't forget the honor that goes out to every magistrate, family court judge, and circuit judge that goes to work every morning trying to do justice to the citizens of West Virginia. I believe I can bring my over 25 years of experience as a circuit judge and hit the ground running at the Supreme Court. I think it's imperative that an appellate judge have the ability to have said they've practiced the same type of law, they've done the same type of work that they're to review. We really can see what's occurring by having people who have not been vetted before as a judge. I'm not a politician. I don't go out seeking endorsements. I've gotten a few, but I think the greatest endorsements I have are the fact that the people that know me best, my community, have reelected me now for 25 years, over 4 times. I think I can bring that experience, the experience that I've had in the first chairman and only chairman of West Virginia Business Court Division, which has been recognized nationally as a progressive court, shining star in the West Virginia court system. I recently received an award from the American Bar Association for the work that we've done with business court in West Virginia. And we're a leader in certain aspects of the resolution of complex commercial litigation. I think it's very important that someone can come to the court, roll up their sleeves, get to work, take care of the backlog of cases that we've seen backing up because of the problems we've had. I've had experience as to the management, not only of personnel, but also fiscal management, being in a growing circuit. I've overseen 3 major courthouse or court annex projects that we've returned on budget and on time. So I hope that I'll have the opportunity to take that work through to the Supreme Court.
Good morning, and thank you for the invitation. My name is Jeff Woods. I'm originally from Greenbrier County. I like to say my first exposure to the system came through my parents. My mother was a cook at the county jail. My father was the janitor at the courthouse. First time I appeared in Greenbrier County, it took me a moment to realize why I was there. I thought I had, because I earned my allowance by dusting the benches in the courtroom at a very early age. So the first time I went, I was looking for a rag and some pledge. But the bottom line is that I am blessed. Because I'm blessed, I believe that to whom much is given, much is expected. And as a result, and I just want to tell you what my blessings are. Since I was 6 years old, I wanted to be a lawyer and a soldier. I got to do both. Okay, I went to West Virginia State College then, now university, on an ROTC scholarship. After that, I graduated in 3 years. I went to the College of Graduate Studies as a graduate assistant. I owed the military some time, of course, and after that, I got a delay or deferment, went to Howard University. There, I had a wonderful time. Grew up wanting to go to Howard because Thurgood Marshall was my hero. And I got to meet Justice Marshall twice. That was an experience. However, I graduated from State and at Howard, magna cum laude, both times. At Howard, I was on the Law Journal. I was a member of the Criminal Justice Clinic, got to practice law in the Superior Court of the District of Columbia. I worked at Wilmer, Cutler, and Pickering. Lloyd Cutler ultimately became White House counsel or general counsel to Jimmy Carter. I worked there, and I also worked at Fort Meade. After that, the Army said, okay, it's time for you to come pay us back. And I got a clerkship with the state Supreme Court. Army gave me 1 more year. And so I did that clerkship. During that year, though, because the director of the magistrate court system became ill, I was elevated, became the acting director of the newly established magistrate court system of West Virginia. So I got to write a lot of policies, a lot of rules, and those kinds of things. And for a young law student, that was or law graduate, that was an experience. I've now been practicing law for 39 years. I went to the Army. I was a prosecutor for the 5th Infantry Division mechanized at Fort Polk, Louisiana. After that, I became senior trial counsel at Fort Polk and represented many of the division's brigades in various matters. Tried everything. Tried 2 capital murder cases. Thank God I lost them both. I won both cases, but nobody got executed because I believe the Army's law at that time was unconstitutional as it related to the death penalty. Nonetheless, after that, I had my first child. Had 2 children, didn't want to go overseas without them, so I decided to exit the military. Came back and became the first African-American lawyer to be hired by a large law firm in the state of West Virginia. I worked at Jackson and Kelly for 25 years. During those 25 years, I was in the National Guard and also in the reserves. Since then, I will tell you, I've earned a PhD in African American Studies. You want to know what I'm bringing to the court? A well-rounded, diverse background, experience, and ability. I firmly believe that there's a difference between self-enhancement, self-advancement, and public service. I'm not a politician. I'm running for one reason only. I'm in love with a beautiful woman. I'm in love with a beautiful woman who is blonde. Her name, Blind Lady Justice. I believe that requires us to deliver fair, just, and appropriate justice to the people of the state of West Virginia. I'll work hard, and I'll say this. We always say, God bless this honorable court in the state of West Virginia. To that I add this, God, keep me young.
Thank you, Mr. Lewis. Thank you all candidates. I appreciate your explanations and your introductions. For the record, I would like to say that there are two candidates that are not here. One is the sitting justice appointed to the seat by Governor Justice, and that is Tim Armstead. And the other one is V.C. Offit, who did not respond to our organization. So many of you touched on the problems going on in court and the credibility problems. I'm sure we'll get into that more during this conversation. But let's talk about, in the last 4 to 6 years, decision-making by the court. Tell us, and anybody can start it off, how have the decisions been by the court? Are they better than they used to be? Are they worse than they used to be? How is court decision-making wise? Whoever wants to start.
I found it to be very good. Most recently, in relation to defending a criminal who was in the penitentiary for some offenses. He came out, he was placed on probation, and when he was placed on extended term probation, I used the most recent Supreme Court decision on that, which resulted in him having to be released from the 50-year prison out of jail this time. The Supreme Court decisions, that was a tough decision for the Supreme Court. They decided to go back and change a decision that they'd been enforcing for nearly 20 years because it was an ex post facto application of the law at that time. They were applying it to people's crimes that occurred before the law was enacted. And because of that, I was able to get them through.
I think recently with the amendments to the rules of appellate procedure, now our Supreme Court has full review of all cases. Previously, the court had what we call discretionary review. And appeals could be granted and appeals could be refused. But if appeals were refused, there was not an explanation for why they were refused. So a litigant could have their appeal denied and they wouldn't have an understanding of why. But now our rules are changed and each case has full review. And there is an opinion and a decision, a written decision rendered by the court in that regard. And I think that's helpful. And in that ways, I think the decisions are better. I do think that we need to work on some improvement with respect to those memorandum decisions. And the memorandum decisions are decisions that are not written by a specific justice. They do not have a justice's name attached to them. They don't have new principles of law. But I think that it's very good that we do have full review. I do think there's some room for improvement with respect to the substance of those memorandum decisions, though.
I totally disagree with everything I've heard here this morning. I'm going to tell you why. Recusal has been a problem at this court, and it's not getting any better until we elect a candidate, and voters are the court of last resort. That mineral rehearing of that case is unconscionable. It should have never, it was decided and then reversed. Secondly,
You're referring to the Leggett case?
yes,
Proceed, sir.
no problem. I'm going to tell you another reason. Those per curiam decisions up there that were mentioned, I disagree with that. Let's have some shorter opinions, but let's offer and have a person actually cite. I I can't cite those in my briefs, and I don't like that. I don't think it's good for my clients, and I want to be able to cite with authority. This is what the justice wrote, and here's why. That's certitude. Finally, the third problem is I practice law in 2 other states, Kentucky and Florida. Our court is not regarded high at all. It drives businesses out of this state, and I'm tired of that. It's not reliable. The decisions, they're not consistent, and we need a justice up there that will be, I've heard totally blind, but it goes further than that. You're not going to hear any bad things or don't see evil, don't do evil. When you come up, if I'm elected, you will get a fair, impartial judge. We all have backgrounds in history, but you set that aside. You look at those papers, you master those papers. I like to see longer oral arguments and shorter opinions. That backlog up there is unconscionable. Finally, right to resign laws. Mr. Lewis hit on something there that is needed in West Virginia. One of the states that I practice law in, if you are a public office holder, this is important, crucial. If you hold any public office in any branch, you must resign immediately before you can declare and file your candidacy papers. We need that in West Virginia. These political job jumpers, they get one job, and there was a judge that challenged that in Florida, and she lost that case. She said it was unconstitutional. I'm not going to follow that. She lost, looked at the judicial pension and said, I've caused a lot of ruckus here, but I'm not risking my sure bird in the hand pension with going out in the rough and tumble world of politics. So that's a reported case. There's other specifics, but I'm going to let me just stop right there. I better stop.
I think the most important thing that we have to do is restore a sense of civility amongst justices. The United States Supreme Court, as diametrically opposed as they are on some of their individual beliefs, has a practice of coming in every morning before argument, shaking hands, and spending 5 or 10 minutes amongst the justices discussing amongst themselves matters outside the court, their families, their vacations. And I think you have to have that civility. You cannot have a court that is divided on personal matters, because that then turns bad opinions out. It's very difficult to put aside your personal beliefs, your personal ideology, your political ideology, and decide the cases based upon the law as given to you by the legislature. But that's the mandate the judge has to accept. And if that law is not offensive to the Constitution, then that law needs to be upheld, no matter what your personal belief is. And I think having been a judge for a long time gives you the ability to recognize that. So I think some of the decisions have been fine, but I think we also are seeing decisions that have been tempered and motivated by either personal animosity amongst justices or by interjecting their own political or personal ideology, which results in unpredictable law. Businesses, attorneys, and most importantly, individuals in West Virginia need to have consistent, predictable, educated opinion so that they can advise their clients, they can advise their businesses, and they can lead their life knowing that there's going to be consistency. It's up to the legislature to change law, not up to the Supreme Court. And I think a lot of that has to do with the civility of the individuals and how they need to act and carry themselves off.
I just want to say this. I agree with a lot of what's been said here. However, I must also say that I was at the court as a clerk when appeals were discretionary. Even though things have changed, it's a matter of form over substance. Yes, now everything gets supposedly reviewed. They're not. Bottom line is it goes to a clerk. A clerk, at best, they decide if it's a memorandum of opinion or a per curiam opinion. And you still, yes, we reviewed it, but you get a memorandum opinion that basically doesn't say much at all. Doesn't actually apply the law to the facts. Therefore, that's a distinction without a difference. The other thing is, I think Judge Wilkes and Judge Cabot are both right. We have good opinions coming from the court. We have some that are not so good. One of the things about being in the judicial system, you're going to please 50% of the people before you at any given time. It's like being a referee in a basketball game. Some people are going to like you, some people are not going to like you. Unless you're doing an adoption, everybody loves you. The bottom line, though, is that we have a court that is not working very hard. If you go back and you look at their statistics, and I just, when I saw it, it just knocked my socks off. If you compare the caseload in terms of signed opinions by the court, they're doing about 20 each a year. That's about it. You look at the caseload for circuit judges, it's up around, and these two judges know more than I do, it's up around 600 plus per judge sitting at the time. Then you look back at all the resources that the state Supreme Court has, and they're just not equally distributed. I firmly believe, and this is what I'm going to say about my two opponents. I don't have anything negative to say about either one of them. They're both good circuit judges. That's why they need to stay down there, because here's the truth of that matter. If we give them the right resources, and they can tell me I'm crazy, it won't be the first time, but if we give them the right resources to do what they have been elected to do and do so well, that's going to decrease the number of cases that are making it to the court. When that number decreases, we can pay more attention to the ones who do come up there, and we can address those issues appropriately. I agree. It just broke my heart the other day when I read some of the testimony from Justice Lowry's, or some of the summaries of the testimony from Justice Lowry's court, especially I believe it was former Justice Benjamin, who said they didn't get along very well. That is inexcusable. No, we don't need to be buddies. We don't need to go do all these things together, but we do need to be collegial. And I can tell you right now, there's not one person sitting on the court, there's not one person who will ever sit on their court who knows it all. We need to be able to sit down, perhaps disagree without becoming disagreeable, and in those instances where we agree, you need to support and encourage each other. If you look at it that way, that will help eliminate the bias. It will also give us better decisions that the people can rely on and know why the decisions came down the way.
Yes, the right to an impartial tribunal is a number one prerequisite before jurisdiction can even attach at court. And in the past, we've had partisan election of judges, and we currently still have some leftovers from partisan election of judges that under the current structure or the future vision for the West Virginia Supreme Court that's been implemented by the legislature through the power of the people, it is clear that West Virginians want a nonpartisan elected judiciary. I can't overstate that importance. Until that occurs, the court has no jurisdiction, and that would go to these the circuit courts and the family courts, because the circuit and family courts derive their jurisdiction from the West Virginia Supreme Court. So it is very important that we have a fair and impartial judiciary before the bailiff calls the case or calls the term to order. And it's my plan to pursue that with everything I have until it's actually accomplished. And I'll let you know when it's accomplished. I think we can do it by 2020 if the people were informed and understand that we all have some biases. We have some members that have worked for large firms here in Charleston that course, they're gonna owe people in their career endeavors. We have, judges that have been appointed, and judges that have been elected. Of course, they could even be biased for their geographic area. And for me, I've gotten rid of I'm trying not to get any endorsements, because I don't think you can get an endorsement and be a non-biased judicial officer. I don't think you can, the only two memberships I had to keep was AAA and Sam's Club. I want that free towing, and I want those good bulk benefits. But other than that, I'll be the most impartial person you could elect. And I also believe I can win. I don't believe the other candidates involved in this race, except maybe Mark Hunt, has statewide name recognition. And I believe that there is good and bad name recognition, but I believe in a 2-month race, it's nearly impossible to get your message out to the voters in this state without a lot of money. And as soon as you start taking money, you have the Judicial Investigation Commission, which I believe this is ridiculous. I can't really criticize our court and our current legal climate, but I will say that what I do along the campaign trail is I describe characteristics of no business land and characteristics of business land. In business land, you have an impartial judiciary that is not biased towards one person or one party or the lawyers. In the past, we've had cases decided by who the lawyers are. We've had cases instead of the merits, and the merits should always prevail. And I will give everybody a seat at the table. I don't care if you're on this way on the left side of the political spectrum or on the right side. I'm going to look at the merits of the case. I'm going to make a judicial determination with no bias. The only person I owe is my mother. Other than that, I have no professional biases. I don't owe anyone anything for my career. And I've always upheld the Constitution. And I've fought and I've told judges when they're violating the Constitution. And I've been either rejected or at some points I've been sanctioned for asking the judge to uphold the Constitution. And that cannot happen in this state. The other thing we need immediate appellate court. And we need that to rein in some of the activist judges around the state that may be biased in their own area and making decisions not based on the merits, but based on the parties involved. That would cut down on that. Rule 17 needs to be modified to allow evidentiary procedure. And I believe we could do a secret type of jury if it would be very, very rare, but in a case where there's actual objective evidence of bias of a judicial officer, it needs to be presented in a forum outside of the public courtroom so that the judge's reputation is not tarnished in the process, but it still needs to be determined by an objectively reasonable person or jury. And that would get a lot of these cases that are biased out of the system. And it would also curb the judges. Some judges may, in no business land, judges may decide cases based on who's before their court.
Anyone else on?
Go ahead.
To follow up on Judge Wilkes, I think that the decisions coming out of our court have been consistent. And I think they've been consistent because of the process. I think being a Supreme Court justice is very different than being a circuit court judge. Circuit court judges work very hard, but they're individuals who make their own decisions without the help of other judges. In the Supreme Court, of course, there's no litigants. It's only attorneys who present issues of law to the court, and the court's job is to take those issues of law and place them with the facts and come up with a decision. But they roundtable these decisions. That's just like what Judge Brooks was talking about. You know, the arguments are made, and then the judges go back the next day or the day after, and they roundtable those decisions. So you have to be able to build a consensus inside the 5 courts of judges to get your decision, the way you think the decision should be rendered, passed. So, in other words, they have help. They have help with law clerks, and they also have help with other judges and how they interpret the law in the round table. And one lawyer, one justice who may be a renegade on the issue cannot carry the day because there's 4 others. So that's the reasons I think the decisions across the process continue to be consistent.
In my experience, the decisions of the Supreme Court over the last 8 or 10 years have been a positive step for the state. I think it's created a more business-friendly environment without being unfairly biased or prejudiced against people who may be injured parties or have claims to prosecute against businesses. When I first started practicing, West Virginia was consistently at the top of or near the top of this publication that coined us as a judicial hellhole. And I think over the last 8 or 10 years, we've removed ourselves at least from the top of that survey because we've been making good strides. And in order to continue that move forward, I think it starts with courtroom experience. All of us sitting here, and you've heard us say today, we all have a substantial amount of courtroom experience. And I think that's absolutely necessary for someone to sit on the Supreme Court. When you look into the breadth of that courtroom experience, you need someone who has handled the issues. I think some other member of the panel here today said, all of the issues that will make their way to the Supreme Court, whether they be criminal or in a civil context, whether those are environmental cases, toxic tort cases, personal injury cases, construction law, all of those types of situations, issues arise which make their way to the court. And it's imperative to have someone sitting on that court who has addressed those issues, in a day-to-day basis. I've spent the last 18 years of my life reading about, analyzing, writing about, and arguing about the law issues that arise and make their way to the Supreme Court. The next thing that is necessary in order to continue this move in a positive direction, as Judge Welch mentioned, is civility in the court. You have to have a group of people there who can work together for a common goal of making the state of West Virginia and the perception of the courts better. You have 5 similar people with 5 similar backgrounds and 5 similar perspectives, you're going to get one answer. You have to have a group of people with various diverse backgrounds who can come together and discuss the issues and arrive at a proper and positive resolution for the people of West Virginia. As far as that goes, my background, of course, as I said, I'm a veteran of the Marine Corps. I've been a practicing lawyer in courtrooms for the last 18 years. I had a solo practice that I grew into a small firm. That small firm merged into the national firm that I'm part of today. For the last 13 years since I started my solo practice, I have been personally responsible for the financial transactions of my solo firm and our small firm. And through my hands has passed millions and millions of dollars of my partner's money and my client's money, without question. So I think finally, and with the particular issues that everyone hears about going on in the court today, financial responsibility is imperative as well.
"15 seconds. The circuit court, there's not consistency there. I've had clients that have had cases there for years, no decision. There is one justice on the current circuit court here in Kanawha County. You'll get swift justice and you'll like it, because my client stormed into my office and said, "We're not going to appeal that. It's too risky." And I said, this is a great justice. You'll get a fair hearing, and there's other cases that I just checked in the other day that case was briefed, fully submitted, and my case was argued and decided within 3 months, and this client, other lawyer, identical issue, identical facts, identical result, has been at our circuit court here. So my point is, let's have some consistency and speedy justice, because we're sure as heck not getting it up at the West Virginia Supreme Court. Thank you.
Okay, so what's the status of electronic filing at the Supreme Court? Like, is there any at all? Yes, sir?
At the Supreme Court, no, it's now in 8 counties. We have called the E-Filing Courts Plus project. My circuit has it in 3 counties, and it is slowly making its way. We have been technologically slow in our advances in a lot of aspects throughout the court system, and the piecemeal distribution of things throughout West Virginia is very difficult for the lawyers because,
So, okay,
you know, I mean, we're moving forward with it, but not nearly the way it should.
thank you. So as a justice, then what would be your priority regarding electronic filing, and what would be your priority regarding public access, including press access, part of public access? Where do you stand on that? We'll start with you. Yes.
I embrace it. I'm the co-chair of the e-discovery, co-chair of the e-discovery committee of the ABA's Business and Corporate Law section. The ability, we've developed our own private inter-office digital retention system for the business court judges, because we take cases throughout the state, and many of our circuits don't have things digitally recorded, so we've created our own. I think it's vital to have that done. I think public access should be the same as it is with a paper file. People so often forget, and I lecture on e-discovery quite a lot, people so often forget the tenets of what the discovery process is and the filing process is haven't changed. It's just the medium in which we retained it. It's digital instead of paper. But I think every courthouse, as we do, should have public access terminals, and ultimately, with the right system, then people can subscribe to it and have access from their offices. If the press wants to subscribe, the attorneys want to subscribe, so that it saves that time to go and do it.
Subscribe at great cost?
No, not at great cost whatsoever. We're one of the very few states that doesn't tack on any fee for e-filing. And the reason that we're one of the very few states is because I don't think we have a functional system right now. Most of the states that have it done use a good provider, and it has to be underwritten by the user, just like many things. Try to keep the court budget to a minimum, but not at a great cost and not prohibitive. There's some things going on now where they make it almost prohibitive to use. And I've always said, you welcome the press, you never invite the press, but you can welcome them to everything, because if you don't, they're going to show up at your door. So I'd rather see you guys come with a smile on your face than with a complaint. But I think it's fine with any state system, especially one that's as demographically difficult as ours is to get around.
Yes.
I'm also licensed practice in Kentucky and North Carolina, so I get to observe the good and the bad about things that go on among those states. With respect to electronic filing specifically, Kentucky is statewide, and it's a very good program, good process. They also have access to electronic dockets. As I said, I have partners in various places all over the country, and for whatever reason, a lot of times I'll get a call and they'll say, hey, I've got this thing going on in Boone County, West Virginia. Can you search the electronic docket and get me a copy of this paper? And I said, well, I can call the clerk and see if they'll fax it to me, but I don't have any electronic access to anything at this point. So as Judge Brooks said, it is being implemented, and I'm involved in various cases, one of which is over in his neck of the woods, but then also a couple of the counties here locally. And where they have implemented that, it is a very useful process and very helpful. But I would like to see us move forward more rapidly, having been exposed to Kentucky. Now, to compare that to North Carolina, I'm not aware of any electronic filing access in North Carolina at all, so in that regard, we're a step ahead. And then I think you also asked about public access to it. I certainly think that, to move on with the transparency, we need to implement public access to the dockets so they don't have to go to the courthouse, dig through paper files to find out what's going on in the circuit courts.
3 quick points on this. I believe in the total paperless law office as well as the court system. This gentleman, I have practiced 4 clients that are totally papered. Every day, it's all scanned in, retained. There's triple backups It's destroyed. There are no paper anything. And huge electronic files. 28,000 pages of documents in discovery. Really? We're gonna deal with paper. And I heard a stat here, at the current rate that West Virginia is going, it'll be maybe 17 years before we go totally paperless. It's a big job, but it can be done, and I've represented some clients that are totally paperless. You will not practice for them unless you have a paperless law practice. So I cross over a lot of, old school, new school. This is the future. It's coming, and if I'm elected justice, that's gonna be #1 priority. Your briefs are all gonna be submitted. Everything is paperless.
Wait, so hand down here and I'll go back. Go ahead.
Don, I voted for the enabling legislation on this back in 2012. I think the project county was Jefferson. Anyway, I also practice in other states. I practice in Kentucky and Florida. Everything the legislator does, there's a yin and yang. For every good thing we do, there's some bad thing that comes as results. Well, I favor the e-filing for we lawyers. It's much easier than sending 10 copies of the Supreme Court. However, in Florida, I see how they do it and what they do, and their rules are so tight with filings, it's almost precluded pro se litigants. It is almost squeezed out the possibility for a pro se litigant to file their papers in the state of Florida, get a hearing, and be able to argue their case pro se. And I think that's something that's granted by the Constitution.
I'm saying you need someone to have a lawyer.
Yeah, someone does it themselves. And so just be mindful. While I support e-filings and I certainly voted for it, there's always a yin and a yang. And in Florida, it's almost eliminated the pro se.
I would respectfully disagree with that statement.
Okay.
Pro
All right, I promise to come back again.
Yes, it's, where I practice in federal courts, and bankruptcy courts, federal courts have had electronic filing for decades now. I remember when it was first implemented, it upped the skill set that my staff had to have in order to operate in my office. People that were before just making copies and so forth and mailing them off to the Supreme Court were not useful unless they could learn to operate a new computer that was set in front of them. And people moved on because of that. Federal court filings are great. You do have to redact what you put on there, and you do have to limit some access to it, because there's a lot of personal information that goes into those filings. Name, social security number, dates of birth, enough to steal anyone's identity if it was released to the public. And same with what is happening with West Virginia and Kentucky. Where you try to implement that, the hard part is deciding what you're not going to allow access to. What do you not allow access to in a divorce? What about a child abuse and neglect proceeding, which I handle? I don't want people reading those anywhere in the state as to what's happening to the show. So they do have to be redacted, and access has to be limited to some degree.
Yes, sir.
I would take a bet that I'm the only person here that has his entire office with him at the present time. I have a 32 gigabyte micro SD card that has all my cases on it. I have another USB that I can take out and put in my copier to scan things. I have a phone that I can get unlimited Wi-Fi. I have a AT&T hotspot if I need it. That gives me Wi-Fi. I have all my case notes, all my filings. I can actually file from here, and there are some clerks that will allow fax. There is a code that allows for filings by fax, but what I've run across, because I've been trying to go paperless since 2001 when I first started practicing Morgantown. I got involved in Yoder v. Workman, one of the very first cases I got out of law school. It was a 1983 case against the current Chief Justice. I think, is she still the Chief Justice? Anyway, it was against her for failing to recuse from Chairman Chapin's divorce case. And then, of course, sending a press release out to criticize and claim that John Yoder was one of the stable of lawyers that was judicial stalking her. And that Judge Hayden determined that that was inappropriate and wrong for her to put it on state Supreme Court letterhead, because then it wasn't a normal judicial act under the judicial immunity. Anyway, the point of that is that in that case, the briefs, and I mean, it got larger and larger, and I kept spending money on ink, and every time I had to print out all the number of cases I had to mail out, even though I was electronically filing everything, they were still requiring service by following up in the mail. And now it's a lot more streamlined in the federal process, and everybody has pretty much been raised up to where they can make a PDF file and then they can submit it online. And the training has been superb in the federal courts. They have free training available to everybody, new attorneys that just get admitted and all that. The state has been way far behind. In fact, I have to file a case in Mercer County, and I've been wanting to file it by fax and pay by credit card, and I can't do that. So that means I have to either go down there and file it in person to get it time stamped and documented and pay with a check, or I have to mail it, put it in an envelope and mail it out and file it and include a check. I think it's way past time that all circuit courts should be able to take credit cards, debit cards, MasterCard, Visa, and for filing fees, they also need to allow, at the current present time, all they have to do is allow for the fax filing under the law that is there already, and then be able to follow that up with some way of paying online. We are way behind. We're still pushing paper. In fact, when I do fax file, I have the local Clay County court that requires me to follow with a paper copy. And I think that I want to get rid of my ink cost in my practice, because keeping a copier going and keeping, not only can you not portably take your office with you as much, but you also end up spending a lot of money on ink and paper, and there's no need for it. There's absolutely no need. If somebody wants to print it out, they should have to print it out at their own expense, but they can receive it by PDF. And I've also fought with the other attorneys on Dropbox, because sometimes as we heard over there, the documents for discovery could get up to 28,000 pages or 30,000 pages. And I think it would be improper for anybody to print that out. Now, there are some old school attorneys that want to see a paper document, and they still want to do that, but I read everything online. I read PDFs all the time, and I got used to it over time. And I think it's something that we should implement into law school level and get it. This is a Chromebook, $200, $250. And these, this is a little more expensive, but this was $99, and then $75 a month to keep service on it. So it is a lot cheaper and a lot more efficient, and that's what we need. We need a cheaper, more efficient judicial department in this state, or judiciary in this state. We also need to rein in the time frames of decisions.
I want to stick with this for now.
Yes.
Okay, thanks.
And I think basically all I wanted to say was I think everything that everybody's talked about can be crystallized in access to justice. And that's what this is really about. And I'm a big supporter of e-filing, a big advocate for that. And obviously we have an Access to Justice Commission that was established by the Supreme Court, and I chaired the foundation to raise money for that. And it's about that. It's about accessibility, it's about convenience, and about affordability for litigants. And I think e-filing gets you there.
Access.
And public access, absolutely. I mean, to everything that the public would have access to, with the exception, obviously, juvenile records, matters subject to protective order, child abuse, neglect things, and all.
Thank you, yes, sir.
So quickly, we think about convenience. And when we think of convenience for a group of people. If the group of people who are benefiting from the conveniences that we're talking about with regard to e-filing. They must be responsible. And what that means is when you take on the convenience, you take on the responsibility for people who may not be equipped to immediately benefit from the very conveniences that you're implementing for yourself. And this sometimes with the e-filing, I agree with it. If you're sitting here as a lawyer, you think it's one of the greatest things perhaps since sliced bread. But if you're one of the people in West Virginia who can't afford a lawyer, you're one of the people in West Virginia who can't afford a computer, you're one of the people in West Virginia who may not have internet in the area where you are really creating a burden on some people, and that has an adverse impact to the ability of people to have access to equal justice. Any system that we have is no better than the people who work in it. The people who work in it will not be efficient or beneficial if they don't realize, I guess the best way to say it is this: we must serve the least of these. When we implement all these things, we can't think about ourselves. In America today, we have seen where electronic technology has gotten us. Some of it is not as secure as we like to think it is. And we have got to deal with things that are going to wreak havoc on our system. So yes, I'm all for e-filing. I agree with everything that's been said here, but the one thing I want to say is let us not forget the very people we serve. Our justice system is not built for lawyers only, okay? The justice system is built for the people. And if we don't keep sight of that and bring the people up to the level that we want to get to, all of it's for naught.
Man, just one quick follow-up. Our rules now require that anyone can bring a document to the courthouse and the clerk has to assist them in scanning it and filing it for them. So, yeah, we do look at that aspect because it's important.
But what about being able to get things, you know, and that's what I'm saying.
Yeah.
So we do owe people some responsibility so that they know what's available and how to access it. So we agree.
Yeah.
But we're just saying, let's not forget the people.
I spoke about Kentucky earlier, and the system in Kentucky, you can file by paper or electronically in every county in Kentucky, and that's the type of system I would support more so here. As I understand, the counties who have implemented e-filing in West Virginia, it's exclusive, other than what Judge Wilson pointed out. But I prefer the system as it's set up in Kentucky to still allow people to have access by paper if necessary.
I would add fax and email to that too, that we should be able to submit documents in fax and email. And that would help on the public access ability.
There's some more questions that we talked.
Well, no, that's one.
Okay,
If you
good.
ask.
Okay, thanks.
Well, as we've talked about today, with the advent of nonpartisan elections, the judicial election is a one-shot election during the primary process, which with the current election before us, theoretically, one of you could win with 100% of the vote, or maybe 46,000 votes statewide. You all have any interest or preference in maybe having a runoff election or an instant runoff if a judicial election isn't won by a plurality in the initial first round, or is the one-off process sufficient?
Short answer, no. I played sports for the last 50 years and still play them. First place, and in speed skating, as you know, the difference between first place and 34th place, 0.03 of a second. We all knew the rules when we jumped into this, and there's no way, I mean, this is a policy question. No runoffs. We're going to have a runoff in this division in 2 years.
As to your question, Phil, I think it would be probably, if there's more than two candidates, I think it would be fair to submit them to primary, have the primary work. If, I'm not talking about this particular election, I'm talking about potential future, because this, having a minority candidate possibly win is, it could be a good thing or it could be a bad thing, but I think with 10 people in 2 months, it's nearly impossible for anyone. We're going to see, this is going to be tested. The power of incumbency is going to be tested in this election, and so will name recognition, the power of name recognition. When I went to political schools back in the early 2000s, they would teach that name recognition is the #1 determinative factor of the vote. And that meant if somebody goes down there, if a voter looks at the list of candidates and they recognize the name and they have a pretty good, decent opinion of that person over all the other names on the ballot, then they were 95% more likely to vote for that person they recognize. We have 480,000 voters that are going to determine this election according to the Hoppe-Kercheval, and a lot of them are in the Eastern Panhandle, where a lot of us are going to have challenges getting our name recognition up because it's the DC market. And we're going to see how many the incumbent usually gets a standard block of voters. And that may be impossible for all of us to overcome from a purely political science analysis of this race. That's basically what it boils down to. So you have a perfect, if they strategize to do this, if certain elected leaders strategize this, it's the old divide and conquer strategy. You get a block of voters that, a little bit of polling that I've heard about, the incumbent is in the 29-28% range. And that's it's very possible or very difficult for us to overcome that. And that's why my challenge is, I'm saying, because of my past election name recognition, and the voters should know a lot about me already, that I think I'm the only candidate that can actually win in this short amount of time. And that's why I'm asking anybody that's opposed to the current sitting justice to vote for me.
A rose is a rose is a rose. Don't care what you call them. And calling judicial elections nonpartisan without changing the system accomplishes nothing. We've seen that. Take a look at what we have right now in this race. If you think this is nonpartisan, then you have been fooled. Okay? You've been watching the wrong hand. You take the legislature, which has a partisan divide in it. You take a governor who ran as a Democrat and 7 months into his election becomes a Republican. Then, when this happens, because of the legislative action, you get two people who were Republicans in either the national legislature or the state legislature, who now get to do exactly what Mr. Hadley talked about, which is run as an incumbent. So it's really as partisan as can be. And anybody who doesn't understand that is allowing themselves to be fooled. I, for one, understood, and I remember reading in the newspaper where somebody said that in order to win this election, you're either going to have a whole lot of money or a lot of name recognition. I'm a firm believer in people. I'm a firm believer in people. And I think that, and I'm not going to insult the intelligence of people. I believe that people will take time, research everybody on this panel if they're interested in this election period. And we need not fool ourselves. Some people don't care. And I can tell you some people don't understand, because I have been hit with this question. I can't vote for you. Why? You're not in my county. You're not my division. Whoa, back up the train. This is a statewide election, okay? And when you have to explain something like that to the electorate, it tells you that people are not as interested as we would like to think they are. It's our job, okay? And I am a firm believer that our court wants, that our state wants a more diverse court than we have already. And that's one of the reasons that I'm running. I am running to bring a wider range of diversity to what we have. If you want to kill partisan elections, go with as much diversity as you can. You ask me, this is not the circumstance for a runoff because we don't have the time. Okay? But if you go back to other judicial elections where you have the primary and then followed by the general election, I'm for it.
I was gonna say, when I was mayor of Williamston, I saw personally the cost of putting on an election and presiding over it. And the cost of a statewide runoff election would be tremendous. In addition, it would be tremendously costly to the people who vote. They would have to make arrangements perhaps to be off work to go vote again. And said, well, did my vote count last time? You know, why are we having a runoff? I don't see it. There has to be finality at some point in time. When we decide the race is over, the race is over.
But I'm sorry, the only thing about that is we're doing it already anyway. It's not gonna add any more expense. If you just look at it very simply, we have a primary, and the primary we elect the judges. We're still gonna have to have a general election. If you would just pick the top two, or however they structured the system at that time, those people can still run in the general election for the runoff. I don't see that that's a problem.
I agree with that. That would be a better system.
I think nonpartisan really should be bipartisan. I think all of us need to get elected on a bipartisan basis. Everybody needs to support us. And if we do this, no sense reinventing the wheel. Look to Pennsylvania or some other states, and they have open primaries. But it's truly a bipartisan.
Not just for judicial, but for other
judicial. It's for judicial. So their judges run in both primaries. If you secure top in both primaries, and you're an unopposed candidate in November, they do not allow someone to write in or pull around and change parties to run. So I think it's very easy to do without a great expense, but we have to keep our history wheel smart. Our Supreme Court, a long time ago, none of our judges often got a majority because we would have 2 Democrats, 2 Republicans, and the top 2 vote getters would win. So you would always siphon down before we went into divisions, which I think is a wonderful thing, so that people can run for it. We've now done it across the board from Supreme Court down to magistrate. But truly nonpartisan is a misnomer in there, what we're looking for is bipartisan support.
15 seconds. 2016, this was the first year, it's my understanding, that we had a nonpartisan election, and that was Justice Walker. So let's not get too, I mean, this is a nice philosophical discussion, but it's everybody on this, to the extent I've been to about 56 places, everybody has been nonpartisan from what I have personally seen, and that's a good thing for this. So we are really setting a precedence here that's worthy, and I like it. We can make this work if we all continue to see the pole star in the sky. I'm asked all the time, are you Republican or Democrat? Because they know before 2016, that's the way it was. But this is so simple. Let's go on with policy. How would you cut the budget up there? That court has $130+ million budget. Let's talk specifics, how that's going to occur. Thank you, I'll shut up.
I'd go even further with adding sheriffs and prosecutors being nonpartisan. And I've actually ran into partisanship in the sheriff's office. And I think that goes back to the Hatfield and McCoy type of thinking when you're using the office of the sheriff or prosecutor for partisan political purposes. And I think we need to get rid of partisan election of prosecutors and sheriffs, because I think that's a fundamental. Our Constitution specifically condemns political tests. That's what it says. Political and religious tests are condemned.
We're gonna wrap up with one more question. If, George, did you want to have a question?
You're all are lawyers, and I think you still are. And what is the most common what's the most common case you had to deal with? And if you want to express your opinion on what is the best solution to solve this problem?
Zora, is your question, what's the most important case?
What's
Each one of these candidates.
what's the most common case that people come to you? Like people come to you they want you to protect their rights. And what is the most common case?
Great question, fantastic. It's never been asked in any candidate forum I've been in.
Okay.
The answer is simple for me. This case, to be elected as a public servant and being able to define public service with great specificity, as I have done here today, to restore public trust, that's the most important case I've had in 43 years of practicing law. The most important case. The court of final judgment in this state under our Constitution is court of last resort. It's you, the voters. So take charge, be large and in charge, and elect me, because there'll be real change. I'm talking real change. That budget will get reduced. And I'm going to start with zero-based budgeting. I've had clients do that. I've had to justify my existence. Mr. Lawyer, why should we keep you around? Thank you. Outstanding.
The most common case that I handle are bankruptcies and personal injury cases. I'm licensed in Kentucky, West Virginia, and North Carolina, and when I get a personal injury case in the door, I'm on the board. And either Kentucky law applies or West Virginia law applies. On the federal level, bankruptcy cases, the most pleasant cases for me to handle are my emergency legal services cases, which are stopping foreclosures on the spur of the moment.
I would like, whoever wants to, just as you answer this question, follow that up with what that means to you. What's your position, or what your role would be as justice citizen?
My role as a justice would be to protect the common citizen of West Virginia. Businesses can hire lawyers to protect themselves. But it's the pro se litigants that come into court that ought to be able to file their pleadings without having to do it electronically. Federal court, state court, you can still file paper copies. They don't like it, but they will scan them. And in federal court, the pro se litigants have terminals in each office, where they can simply sit down and access them with the assistance of the clerk.
Yeah, that's a difficult question to answer. It's a good question. It's a difficult question to answer. I can't pick a particular case or a particular type of case. It's either more important to me or more common. The important case is the case I'm working on at the moment, because whether it's criminal context or a civil case, an abuse and neglect, mental hygiene, and I've handled all of those. I'm always working to protect someone's rights. Sometimes it's the rights of liberty, life. Sometimes it's property. But those are all, as you address, and that's the way lawyers have to approach each and every one of their cases. It's the same situation being a justice of the Supreme Court. You have to work to ensure that the circuit courts are applying the law fairly and consistently and impartially as it exists. The Supreme Court, the circuit courts are no place for politics, no place for creating law. The courts exist to ensure that the law is enforced as it exists.
As I understand your question, I think that we all down this table practice different kinds of law.
Yeah.
And me, I'm a personal injury lawyer. That's all I've ever done for 25 years. I represent people that have been injured, and I represent people who normally couldn't afford to pay a lawyer. Because the type of work that I do is I do what's called a contingency fee. If someone comes to me, I take their case, I handle the case. If we're successful, and I've only not been successful once, if we're successful, then I take a third of their money. And so they don't pay me up front. If I lose, I don't get paid. But in many cases throughout this country, especially in West Virginia, these are the only type of lawyers that some individuals can get, because they simply don't have the money to spend $600-700 an hour and pay the lawyer that, plus maybe a $10,000 or $15,000 retainer fee up front. So that's what I do. And I've been doing it for 25 years. As far as being a Supreme Court justice, I think it would be my job to interpret the law and not make one. I've read the Federalist Papers, and I thoroughly believe the court's job is only to interpret the law, interpret questions that are brought to the court, not overreach, and interpret the law and not make law. Making laws is the province of the legislature that gets elected every 2 years. And if you don't like what they're doing, throw them out every 2 years. So that is the province of the legislature. So hope that answers.
Yeah.
In my 17 years of practice, private practice, I've handled almost all types of cases that there are, including bankruptcy, divorce, custody, child support, personal injury, corporate law, civil rights, employment law, state law, property law, oil and gas, criminal law. And I've, in that time, clearly my favorite cases are adoptions. My worst cases are abuse and neglect, especially when they involve a parent that's addicted to opioids. And I really have a strong animosity towards what's been done to this state with drug addiction. And I've seen parents choose to smoke meth and lose custody of their children. And those are the cases that you beat into their head that it's up to them, that they have to pass the drug test. They have to be the one that becomes a responsible adult in the situation, or else they're going to lose their kids. And you watch them make the choice and not work with CPS. And our CPS offices are out of control. Their lack of funding, lack of hiring practices. We've got problems all along the abuse and neglect spectrum. And the other thing we need to be careful of, where the government comes in and takes a child, then they need to exhaust all reasonable alternatives, as the code says, before they take a child. That means checking with the family member.
You want to just how that would relate to your as justice?
Oh, as justice, I'm going to hopefully, Bo was talking about how we're going to cut the budget and use the budget. I believe in supporting the drug courts that the two judges here have familiarity with. But we need to expand the drug courts and make sure that it's well funded. That is one reason that the office upgrades are such an affront to the West Virginia voter, because they could have put that $5 million into the drug courts or the juvenile courts. And I also want to implement the business courts. So we need to work to revamp the abuse and neglect. We need to find ways to intervene and rehabilitate these individuals that are suffering from addiction. A lot of it comes from traumatic experiences from their childhood. It's been found that that's a direct link to addiction and the propensity to do drugs in the first place. So we need to help in the abuse and neglect area and juvenile matters. We need to support that with all the financing that we can get.
And so I understood your question to be, what was the most common type of case that we had? And I'll tell you, I had a lot of private practice before I came to judge, And if I thought that the courthouses were built for the work that my clients did when I was in private practice, I was wrong. Because I see something completely different that is the most common thread running through most of the cases that I have in front of me. And as Mr. Lewis mentioned, the abuse and neglect is very challenging, very common, but it's the opioid crisis and it's the drug crisis in our state that really seems to transcend everything. And it's in juvenile cases, it's in criminal cases, it's in abuse and neglect cases. And we struggle with that. And I'm a presiding judge in Kanawha County in our juvenile drug court. And certainly an advocate for treatment courts because those definitely help youth that are suffering from substance abuse disorders and issues and the like. And with respect to adult courts as well, you know, those can cut down recidivism and promote rehabilitation and make people healthy, productive members of society. It helps the individual and it helps their family. And those are typically the most common types of things I see. As it relates to my work as a justice, I see myself really as a justice for the people. And I would like to work in addition to the work that I will be doing, obviously, as a justice presiding over cases, working toward promotion of treatment courts and the like to help deal with this addiction problem because studies bear that out, that if properly implemented, it works.
I agree with Judge Tappan that what we've seen now, the prevalence is the child welfare cases that really permeate the courts and it takes up a lot of our time. Probably the number one filings are civil filings, but they often take care of themselves before you have to try the case. And I think that what we have to do is recognize that we need an equitable distribution of the judicial resources to all the circuits in the state so that we can develop tools in which to combat the opioid crisis, other drugs, amphetamine comes in. And we have seen in my area, we've got what I consider the most progressive day report center and work release type setup, community service setup, because you don't just need to treat an individual who likes to do drugs. You need to treat that individual and give them a sense of worth so that when we can bring them in and work on the drug addiction, but also get them employed, give them skills to move forward with, you have to treat the whole individual. Now, philosophically, I don't believe that that's the job of the courts. I believe it's the job of the executive and the legislature to do that, but we've seen that that's not being done and it's come to us. In my quarter century of working as a judge, I've seen what we've had to do by way of abuse and neglect, by way of now the opioid crisis. Someone asked me the other day after the radio show, they said, what is the biggest difference in the criminal you see today than when you started? And I like to say, well, when I started, I would see criminals that have to use drugs. Now I see people who are criminals because of drugs, and we need to really approach that. And I think as a justice, what I would do is, number one, like I do now, every case in front of me is very important to that individual. I'm always taking the position of judge is like a doctor. If you're in that hospital, you hope that you're the most important patient, that doctor. Well, it's the same thing when people come in front of you. We can't forget that no matter what decisions we make on a conceptual ground, they affect people's everyday life. So it's very important we remember that. But I think it would be the equitable distribution of assets throughout the state so as to assist all the individuals that are having these needs and all the communities that are willing to work with. We've got a lot of ground roots work out of all our communities to try to help with this problem. I think it's our job to do what we can to assist with.
There's no one who can dispute that we're in need of a change. We're in need of a change, and as the old saying goes, if there's to be a change, let it begin with me. I grew up after Brown versus Board of Education, started school after Brown versus Board of Education. I still went to a segregated school. First black kid to go to Lewisburg Elementary School. When I thought about that, I thought about something my mother said to me. You have a gift. If you don't share the gift, God's going to take it away from you. As a result, I think the most important cases that I have are cases that involve people and their rights. The Judge Leonard Hand said that everybody's entitled to a hearing. That's fundamental due process. But what does it mean to be heard without a lawyer? So a part of my life has been spent ensuring that the underprivileged have competent legal advice and representation. Whether that I have given them that, that's for them to decide. But here in the state of West Virginia, we give away an award for the lawyer who gives the most of his time to underprivileged and indigent people. I've won that award 3 separate times. Why? Because I give what I've been blessed with. I haven't lost anything in between. I was able to rear my children. My oldest daughter is an emergency room physician. So I haven't lost anything. My other daughter is a teacher. I have 3 stepchildren. One's a nurse, one's a beautician, and my son's a carpenter. I haven't lost anything, but this much I can tell you. This much I can tell you. You asked me what my best case was.
What the common case, not the best one, but the most. Yeah,
My most common case, I would still say, is giving quality legal representation to underprivileged people. The greatest fee I ever got wasn't a contingency fee. It came in a case I did for free. And that fee was when a grandmother kissed me on the cheek and said, "God bless you, son." Okay, because at that moment, I knew that I had turned an entire family around because they got competent legal advice. I like to go back and just, I want to end with this. There was a person that said something once, and that person's name was Gideon. Brought us a case called Gideon versus Wainwright, which says that you can't afford a lawyer, one will be appointed for you. Gideon got us that case because all he said was, "That ain't right. You can't try me and send me to jail if I don't have a lawyer. That ain't right." And that has stuck with me. And so what I'm saying is, as a justice, I will have in my arsenal the ability to say, that ain't right. Because if we're not ensuring that people get equal justice under the law, then guess what? Not only is that not right, we're not right.
Thank you all very much.
Thank you.
Thank you.
Can we ask Laura a question?